Thank you. I'll have an opening statement up. First, I want to welcome everybody again to this hearing. EPA mining policies, discussion about assault on jobs, and we'll have a part two of a hearing next week. Coal mining is an important aspect of the nation's mining industry and is woven into the fabric of Appalachian life. Today, coal is mined in 26 states. While Wyoming is the leading coal-producing state, it is closely followed by West Virginia and Kentucky. The United States consumes 1.1 billion tons of coal every year. 33% of the coal, approximately 390 million tons annually, comes from the Appalachian region of the United States, and 50% of the power is generated in the nation comes from coal as the fuel source. Coal is an abundant and domestic source of energy. Its use is not subject to the whims of the foreign cartel, nor is it tend to thrust into international conflicts. In addition, using domestic coal creates American jobs. While it is important to continue our research and development into new sources of energy, it is clear that coal will and must remain a major source of energy well into the future. And therefore, it is important that we keep coal as a safe and inexpensive alternative to other energy options. For this reason, I am concerned about the Environmental Protection Agency's recent policy decisions regarding coal mining activities. It would appear that the objective of the agency is to make coal mining so expensive that alternative sources of energy will become more attractive. The effect of such a policy is to significantly drive up the cost of energy. Since energy cost is a factor in all aspects of our economy, this policy will act like an anchor that drags down our short-term economic recovery and our long-term economic global competitiveness. While Congress has passed no law amending the Clean Water Act and the Environmental Protection Agency has promulgated new regulations changing the Clean Water Act, EPA has issued draft and interim guidance and substantially changes how the Clean Water Act applies to surface mining and is using it as a de facto law to unlawfully delay or kill Clean Water Act permits for surface mining operations in Appalachia. In doing this, I'm extremely concerned how the administration is attempting to short-circuit the process for changing substantive agency policy under the Clean Water Act without following the proper, transparent rulemaking process that is dictated by the Administrative Procedure Act. By ignoring the Administrative Procedure Act, EPA is changing the Clean Water Act and is implementing of regulations. EPA is taking these actions with little regard to economic consequences, with little regard to national security, and most importantly, with little regard to the law. Much of the Clean Water Act is delegated as a delegated program. States that have received approval to implement the Clean Water Act programs have demonstrated to the Environmental Protection Agency that they have adopted laws, regulations, and policies at least as stringent as the federal laws, regulations, and policies, and these states have developed and demonstrated the capability to maintain existing and assume new responsibilities under the Act. Congress and the Administrative Procedures Act and environmental statutes establish a formal administrative rulemaking process that provides a mechanism for public comment, proposing amendments, or allowing states to object and provided standards for judicial review of agency actions. Section 404 of the Clean Water Act assigns the EPA to two tasks in regard to fill material. First, EPA must develop the guidelines in conjunction with the Corps of Engineers in determining whether to permit a discharge of fill material. Second, the Act confers EPA the authority under specified procedures to prevent the Corps from authorizing certain disposal sites. EPA guides the Corps' review of the environmental effects of the proposed disposal sites. For example, no permit shall be issued if it causes or contributes to any water quality standard violations. EPA may comment on the Corps' application of Section 404 guidelines to particular permit applications during the interagency review period required for each permit. In addition, EPA has limited authority under Section 404 to prevent the Corps from authorizing a particular disposal site. To exercise that authority, EPA must determine, after notice and an opportunity for a public hearing, that certain unacceptable environmental effects on municipal water supplies, shellfish beds and fishery areas, wildlife or recreational areas would result. But EPA does not have the authority to revoke an already issued Section 404 permit. Even though the EPA is very much involved in the permit application process, along with the state and the Corps of Engineers, and other federal agencies, the EPA is now revoking permits that have already been issued. That is illegal. That is not legal. EPA is clearly ignoring the Clean Water Act and other laws as it relates to surface mining activities in Appalachia. EPA's continued imposition of interim guidance, interim rules, draft policy, or reinterpretation of policy has led to uncertainty regarding actions taken by the state and federal regulatory bodies. In addition, it is simply not a responsible way for government to act. This regulatory overreach should be considered a property rights issue. What does it really mean to get a permit? Should it come with some certainty? Shouldn't it come with some certainty that the activity can move forward unencumbered, but within the bounds of the permit, particularly those activities on private lands? This no longer seems to be the case, and is going to have stifling effect on not just mining operations in Appalachia, but on economic development projects nationwide. While the President and his administration talks a good game about job creation and removing unnecessary governmental burdens on business, in reality, the Environmental Protection Agency is crippling economic growth with little or no benefit to the environment. I welcome our witnesses to the hearing today. I look forward to hearing from each of you in the next coming minutes. But this time I want to recognize the ranking member of the T&I Committee, Congressman Rahal.